Florida is a 2014 United States Supreme Court case Indiana which the court held that a bright line IQ threshold requirement for determining whether someone has an intellectual disability, formerly mental retardation, is unconstitutional in deciding whether they are eligible for the death penalty. Virginia, which left the determination of what constitutes intellectual disability to the states. Scores: 2. A lack of fundamental social and practical skills, and 3. The presence of both conditions before age 18. States can designate an individual convicted of murder as too intellectually incapacitated to be executed. The court prohibited states in borderline cases from relying only on intelligence test scores to determine whether a death row inmate is eligible to be executed. States must look beyond IQ scores when inmate tests are in the range of 70 to 75. IQ tests have a margin of error, and those inmates whose scores fall within the margin must be allowed to present other evidence of mental disability. The court further held that the states may not use a rigid rule that denies leniency to defendants with severe mental disabilities simply because they score above 70 on an IQ test. Kennedy wrote for the majority that this rigid rule, the court now holds, creates an unacceptable risk that persons with an intellectual disability will be executed, and thus is unconstitutional. The court also adopted the term intellectually disabled to replace mentally retarded, which had been used in prior opinions. Intellectually disabled refers to people of limited intellectual and adaptive capabilities, according to the American Association on Intellectual and Developmental Disabilities, and the term is preferred by the medical profession.